Immediate red flag, the defendant blurting, "These allegations are false" on Zoom. Quick legal note. An arraignment isn't the place for a full defense. It's where charges are formally read and rights are confirmed. But emotionally? That instant denial is a classic tension builder. The audience now wants to know which version is true. What would you believe at first glance?
Go ahead.
Your Honor, these allegations are false. The victim has came forward and said that she lied. Your Honor,
all right, I'll
she
see
is
Mr.
my
Fitz here by
fiance.
3 o'clock today.
She is my
Who's that with you,
fiance,
Mr.
Your
Fitz?
Honor.
Who's that with you, Mr. Phipps?
This is
Who's over to the side of your camera? Who's over to
Jasmine,
the
my
side
wife, my soon-to-be wife, Your Honor. That's
All
why
right,
I needed to talk.
I said what I said. You're to be in this court in person for your arraignment by 3:30 this afternoon. And your attorney can appear via Zoom. Call your lawyer. I'll see you by 3:30.
Judge is worried. Listen to the tone. Legally, that line foreshadows bond conditions and possible restrictions. Practically, the judge just signaled this isn't a run-of-the-mill misdemeanor. Stakes are rising. Takeaway. When a judge tunes in like this, expect tougher pretrial controls.
Good morning to you and your staff. Jonathan Jones, 52920, appearing on behalf of with Mr. Phipps. Thank you for letting us do this remotely. Obviously, we consent. To the arraignment, Your Honor, I'm going to acknowledge receipt of the general waive his formal reading and send a mute.
All right, I'm a little concerned about these allegations and the fact that Mr. Phipps doesn't, I mean, he's not in custody, but he's going to have some significant bond conditions.
Excuse me.
Quick explainer. No contact orders are not suggestions, and they're court directives. If the prosecutor says the complainant reached out independently, that complicates the no-contact narrative and raises questions about witness reliability and potential witness tampering. Audience hook, did they reconcile or is someone manipulating the record?
Michael, be quiet, please. Judge, if I may, I understand where you're coming from, but I want you to know as an officer of the court that the complainant has reached out to me independently. I'm going to leave it at that. He has not had any contact with her. He will not have any contact with her. I want the record to reflect that the court scheduled this. We're grateful. We're here. He's absolutely not a flight risk, and the conditions of no contact have been respected and will remain in that manner.
Jonathan.
Yeah.
Michael,
No,
please
I mean,
do not speak.
Mr. Phipps, listen, you're have an attorney. If you want to say something to the court, you're free to do so, but you have a right to remain silent. You have a right to have counsel. So is there something you need to say?
Yes, there is something. Yes,
okay,
there is something that I need to say.
Good, tell me.
Well, I would like to talk to my attorney real quick because evidently he's not aware of anything.
Oh, he's not aware of anything. All right, you know what? You need to be here in person today. You have until the end of the day.
Your Honor.
Judge,
I need you in person at the 23rd District Court in person by the end of the day. I can put you two in a breakout room. You're coming.
Big pivot. Judge demands in-person presence by 3:30. That's a power move. Why? Courts use physical appearance to control credibility and immediate compliance. This raises the tension. Will he show up? If he doesn't, bail or arrest could follow. Poll the audience. Would you risk it?
In person, I'll see you in a little while.
Judge, I cannot be there in person. I'm scheduled
Your
for
Honor.
1 o'clock, and today is the Jewish holiday. I cannot be there in person.
Why can't
Well,
you
your
call
client
me?
can.
Well, that's fine, Your Honor, but I'm not going to be able to be with him. I'd like to get him arraigned now. He and I can speak.
No, I want him. He is charged with a home invasion first degree.
Your Honor, can I speak,
He is
please?
charged with a home invasion first degree. He is charged with.
Your Honor, can I please speak?
I'm not. Do you hear me talking?
Yes, ma'am.
He is charged with a 20-year felony. He is charged with assault with intent to do great bodily harm, less than murder or by strangulation. He is charged with domestic violence. He is charged as a 4th habitual offender. He has multiple prior assaultive convictions. I want him here in person. I've said what I said. I said what I said, make it happen.
Your Honor,
You
can I
have
speak,
until
please?
You have until 3:30 to turn yourself in.
Pro tip for viewers. Audio evidence is huge in court. It's visceral and hard to spin. The judge asking to play the call is a narrative weapon. One clip can undercut a whole story. Watch for tone, pauses, and who hangs up first. Those tiny details often change the case.
The court.
Your
for
Honor,
an
can I please
arraignment.
speak, please? Please say something, please.
Go ahead.
Your Honor, these allegations are false. The victim has
Okay.
came forward and
Oh,
said that
okay.
she lied, Your Honor.
All right, I'll
She
see
is
Mr.
my
Fitz here by
fiance.
3 o'clock
She
today.
is my
Who's that with you,
fiance,
Mr.
Your
Fitz?
Honor.
Who's that with you, Mr. Fitz?
This is
Who's over to the side of your camera? Who's over to
Jasmine,
the
my
side of-
wife, my soon-to-be wife, Your Honor. That's
All
why
right,
I needed to
want
talk.
I said what I said. You're to be in this court in person for your arraignment by 3:30 this afternoon. And your attorney can appear via Zoom. Call your lawyer. I'll see you by 3:30. Oh, Mr. Verdute, you're here to cause some trouble, I see. This is 250941, the People versus Jessica Glask, Jazerski. All right, go ahead, counsel.
James Gazicki on behalf of Mr. Jazerski. I just received the file today, and she's gone over her rights. There's no question regarding her rights, but we're requesting a hearing in this matter. I'm asking the court for an adjournment so I can review the file and be brought up to date in this matter.
All right, well, where you should start is you should ask Ms. Wagaman to play you the audio of a call that was submitted to her where Ms. Wagaman contacted the defendant about not having any contact yet again with the complaining witness. And she hung up with him and then immediately called the complaining witness and had a phone call based on her call with Aaron. That might be a good, I'll adjourn it, Mr. Gizicki. I'm just telling you that might, you don't have to go into it too much. You could just listen to that call. She has a no contact order. How many times do I have to tell you that? How many times?
I understand.
No, you don't understand. Because no, and what did I tell you? What did I tell you when he calls you? What did I say? And what'd you do? Instead, talk. You are not supposed to be talking to him by my court order. And this is the second time I've seen you. And the last time I said, this is ridiculous. Don't cry now.
Courtroom mic drop. Probation revoked and 90 days jail. Short legal breakdown. Revocation means the judge thinks the supervised plan failed and opts for incarceration instead. Dramatic reaction. The judge loses patience and the courtroom turns from counseling to consequences. Final question for viewers. Does punishment fix toxicity or does it just paper over deeper problems?
Last time I said, this is ridiculous because he's contacting her and these two are going back and forth. And then I counseled you and said, do not respond to him. If you respond to him, I'm going to put you in jail. There's no contact. And you can't listen. I mean, you can't. And Mr. Verdute, don't think you're cute because I'll see you next week on a violation. Am I seeing him this week?
No, he'll be here next week.
He'll be here next week. You two are toxic, and this is what's irritating me. You're wasting time on the criminal justice system's time on whatever you two have going on between you. You're wasting the time of the courts. You're using the criminal justice system. Mr. Verdute, I'm looking at you. You're using the criminal justice system to deal with your two little petty problems. That's what you're doing. And I'm tired of it. And what's becoming clear to me is that maybe probation is not suitable for either of you on your cases. And maybe it'd be best if you just do your jail time and we get this over with. Because I am not going to play this game. I'm not going to ask Ms. Wagaman to play this game for much longer. This is it. So we'll set it for a hearing. Mr. Verdute, I assume you'll be recording when she calls you after this hearing. Make sure that Ms. Wagaman gets that, because if you call him in between now and your hearing, you have any contact with him whatsoever, I want to be clear. I am revoking your probation and I am locking you up for 90 days. One time. Do you understand me?
I understand.
Are you sure?
I'm sure.
One time. If she gets one thing that is from right now at this moment, at what time is it? 3:57, Monday, September 22nd to next week when we have your hearing, bring your toothbrush and wear a sports bra because you're going to jail. Got it?
Got it.
All right, we'll set up for a hearing. And Mr. Verdude, your violation, you better come in person. Don't show up on Zoom.